Making a will. You've invested carefully over the years. You've made a solid financial plan. You've got your insurance in place. You've taken all the necessary steps to make sure your family and dear ones will be financially secure, even in your absence. Is there anything you've overlooked that could derail your plans? While you may feel it's too early to think about it, the lack of a will can pose major problems to your loved ones in smoothly inheriting your wealth. Contrary to what many think, a will is not just for the super rich or for those with plenty of assets. A will is a necessity for anyone who has any assets that need to be distributed after their death. The absence of a will can seriously undermine all the efforts you've made to create your wealth. In a best-case scenario, it will lead to unnecessary delays and expenditures for your survivors to impartially distribute, and later, get the assets legally transferred to their names. In a worst-case scenario, your wealth may go to those you wouldn't have wanted to give anything. While disputes about who gets what and long-drawn legal cases are understandable, there are also instances of people or institutions disputing the legal rights of the survivors over a property or asset. In such a situation, your survivors will be left with no option but to run from pillar to post collecting documents or fighting out long-drawn cases in the court of law. Would you wish your near and dear ones to go through this ordeal? All these time-consuming, expensive, and emotionally draining situations can easily be avoided by leaving a will. If you are looking forward to your retirement years before writing a will, please don't wait. Life may not work out as planned for everyone. So prepare for the worst-case scenario. If you have assets and dependents, it's time you took paper and pen and started writing your will. The good news about writing a will is that you can do it in a matter of hours. To start, create a list of all the assets you own. Then decide who gets what after your demise. Once you've got that clear, write it or get it typed on paper. Then, mention the date, location, and sign it. Finally, get two people who are not included in the will to sign as witnesses. That's all. It is not mandatory to register the will or type it on stamp paper or get the services of a lawyer. However, if you have property in your name, it is ideal to get your will registered. If you feel your assets are too numerous or complicated to divide, then it is strongly advised that you get the services of a lawyer or an expert in the field to help you write the will. This will ensure that there aren't unnecessary complications due to lack of clarity in your will. Even otherwise, leaving an unregistered will is better than not writing a will. So write one soon. A will can be defined as a document that states how the wealth of a person gets distributed after her demise. A person making the will is called a testator. The people or organizations that receive the assets mentioned in a will are called beneficiaries. A will can be made by any Indian who is mentally sound and over the age of 21. A will can be defined as a document that states how the wealth of a person gets distributed after her demise. A person making the will is called a testator. The people or organizations that receive the assets mentioned in a will are called beneficiaries. A will can be made by any Indian who is mentally sound and over the age of 21. Although there are no strict rules to be followed, for a will to be clearly understood, it should have the following parts. 1. A declaration with the name and address of the testator. 2. A list of assets, and to whom they should be distributed. 3. The names and addresses of the executors to the will. 4. The signature of the testator. 5. The signatures of 2 witnesses. 6. The date on which the will was made. You should declare that you are writing this will without any outside pressure or influence, and that you are mentally fit to write it. You should write your name, age, and address to identify yourself clearly. You should list each asset you own, and clearly mention who should get ownership after your demise. Be as specific as you can while writing this part so that there is no confusion later. For example, if you have 2 fixed deposits in a bank that you want to allocate to your children, you should mention clearly who gets which. The fixed deposits can be identified by their serial numbers or their maturity amounts. If you have gold jewelry that you would want to be distributed amongst your survivors, be as specific as you can. Provide a description of the jewelry along with its weight, current cost, so that there is absolute clarity during distribution. In case there are assets that can increase or decrease in value or quantity, it's better to mention the distribution in terms of percentages. For example, you may currently own shares of 20 companies, or maybe 500 shares of a company. This number may increase or decrease as you keep buying and selling shares. Here, instead of writing the number of shares that each beneficiary will receive, You can mention their share in terms of percentages. For example, you could write that each of your 2 children will get 30% of the shares you have, while your spouse will get 40%. This way, they needn't go to the courts to decide if there are any discrepancies in the actual number of shares. You could also mention where the documentation for each of these assets is kept. Nowadays, many people hold assets in online accounts. Mentioning the login details of such assets will be really helpful for your survivors. When a person dies without making a will in legal terms, that person is said to have died intestate. In this case, the property gets distributed as per law. So what exactly happens to the assets owned by the person? Does it automatically go to the spouse and children? Do their parents or siblings get a share? What about other close relatives? The answer is not simple. Hindus, Buddhists, Jains and Sikhs are governed by the Hindu Succession Act, 1956. The act was amended in 2005 to give additional rights to daughters. With the exception of Muslims, everyone else, Jews, Parsis, Christians, etc., is covered by the Indian Succession Act, 1925. For Muslims, the properties pass on to their heirs as per the Muslim personal law, which is based on their religious text. If you are a Muslim, you should remember that as per Muslim personal law, you cannot give away more than 1/3 of your assets to anyone who is not your legal heir. It is also necessary to get the permission of your legal heirs before you can leave this 1/3 of your assets to someone else. The remaining 2/3 of your property will automatically go to your legal heirs. If you do not make a will, all your assets will be divided amongst your surviving relatives, as per Muslim personal law. In addition, Muslim personal law does not require a will to be made in any particular format. It can be in writing or even communicated orally as long as it is clearly understood by the heirs. The distribution of assets in case the deceased does not leave a will is thus carried out along religious lines. As per the Hindu Succession Act, if a male dies without a will, his heirs are divided into 2 main classes, Class 1 and Class 2. As per the Act, heirs in Class 1 have first rights over Class 2 heirs. Only if the deceased doesn't have survivors in Class 1 category do his assets go to his Class 2 heirs. If there are no Class 2 heirs either, then the assets will first go to his agnates, distant male or female relatives, related uninterruptedly through a male lineage. If there are no agnates, then the assets go to his cognates, distant male-female relatives, related through one or more females. The law treats natural as well as adopted children as the same in case of inheritance. So in all the above cases, the adopted son or adopted daughter will have the same rights as the natural son or daughter. To avoid this kind of complex distribution of your wealth, it's best to leave a will that clearly states how you want your assets to be distributed, and to get the services of an expert in the field.